and appointments. I want to bring to bear on the debate the fact that we are observing that other institutions of state that are supposed to be independent in the performance of their functions are being polluted with political persons. And that is a worry. Mr. Speaker, this court is presently constituted by about 14 judges, and told that about 4 of them are due for retirement or are on retirement. There is another unholy observation, and that is the decision by the Chief Justice to extend beyond 70 years the life of a judge on the Supreme Court. It's totally unconstitutional. It is only the appointing authority, which is the President, that can extend the life of a judge beyond 70 years on the bench, not the Chief Justice. But it is happening. A judge retires at attaining 70 years and he will continue to hear cases beyond 70 years. And it is also a worry. And yet we cite the same reasons. We cite the same reasons to say that because these are going on retirement, so we should replace them. Mr. Speaker, one other worrying trend is the fact that during the 2023 budget hearings in December, for purposes of approving the budget, the Judiciary told us that because they want to make access to justice more economically cheaper and more closer to the people, we should approve of their budget and even enhance it so that judges and courts can be more closer to the people. And in doing so, they intend to recruit, in fact, 15 more Court of Appeals. That was done in December. 15 Court of Appeal judges were recruited. Mr. Speaker, in January, the Chief Justice issued a letter suspending Court of Appeal hearings in Cape Coast, in Ho, in Procedural, in Tamale. How is it possible that you want to make just access closer to the people, and yet you have down courts that are closer to the people, so that an appeal from say Tulu must be brought to the Court of Appeal in Kumasi, and an appeal from say Karachi or Nkwanta in the Oti region be brought to Accra. They could have done that hearing at the Court of Appeal level in Ho. So, Mr. Speaker, we are worried about these sort of developments within the judiciary. By all means, we want you to appoint persons to hear matters on the bench. But when you tell us that we should increase your budget because we want to bring justice close to the people, and when we increase the budget and approve of them, and you close courts that are closer to the people and bring them to the metropolitan center, this house ought to be worried. Mr. Speaker, Justice Kumsin tutored me as a young practitioner in 2010 thereabouts, and it is good that it is incumbent upon that fact that it's been elevated. Mr. Speaker, Justice Garu, whom I know very well, it is incumbent that he is being elevated. But the circumstances upon the elevation, Mr. Speaker, is what is of worry to us. Mr. Speaker, we are saying that in November 2022, 2 Supreme Court judges have been nominated, vetted, and appointed. Mr. Speaker, in December, 15 Court of Appeal judges have been appointed. Mr. Speaker, early this year, sometime early January, 21 High Court judges have been appointed.
By the same president.
Mr. Speaker, we were told in this house just a couple of weeks ago that the president is only building about 6 high court judges, high courts, which are under construction. So it is the overpopulation that is of concern to us. It is the overpopulation that is of concern to us. Not because we don't want the bench to function. Because we want the bench to function, but we are saying that it is becoming top heavy. It is becoming top heavy to the extent that even those who are on retirement, you don't want them to go. Today, the other uncomfortable practice is asking Supreme Court judges to act as additional High Court judges, bringing them 2 levels down. Mr. Speaker, when they enter judgment as a High Court judge, and it goes on appeal to the Supreme Court, would the Supreme Court be deciding on that matter as a judgment from a Supreme Court judge or as a judgment from a High Court judge? Because for a judge to enter judgment, the level of reasoning is not only on the level that he operates from. So when a Supreme Court judge enters judgment at the High Court level, it is troubling that the Supreme Panel will reverse it on grounds that it is a judgment from the High Court. That is my humble view on the matter. So by all means, let High Court judges operate courts, and let the Court of Appeal operate at the Court of Appeal, so that the way Yahweh says that the Supreme Court has varied original jurisdiction in several other matters, and the Supreme Court today has so many cases that when you file a matter that is of constitutionally urgent interpretative matter, it doesn't take forever to be heard. Mr. Speaker, with these few words, I thank you for the opportunity.
I want to summarize.
Yes.
Thank you for the opportunity given me to contribute to the motion, approve the nominations by the President for these 2 Supreme Court judges. In this country, there are certain organizations that we need to be very careful and make sure that we do not extend our partisan behavior into them. One is the Judiciary, and I can say that if we try to be partisan with the Judiciary, the nation will break down. Another is security. We must take our security measures very serious, so that on both sides of the divide we can come to consensus. Mr. Speaker, I would want to caution that we must be very careful in trying that we want to appoint judges, and we don't want any of them to be partisan or tilted towards a certain party level or be political in nature. We ourselves, we must not be seen to be partisan or political. There are 2 judges. Earlier on, my colleague Honorable Boama has cited Constitution Article 1284, and it says that a term of 15 years standing at the bar and of high moral character qualifies to be at the Supreme Court. There are a lot of judges that have been picked from the bar because of their experience and goes to the bench, the person is going to tilt towards one political party. And I think this is very speculative. We must actually look at what they have given to the nation, the contributions that they have given, and I think they are more than qualified to be at the Supreme Court. Mr. Speaker, we should not wait until the problem arises before we find solution. It is clear that most of the Supreme Court judges have either retired and some are going to retire. It is clear that most of the Supreme Court judges have either retired and some are going to retire very soon. There are times that we call on a full bench and we have to call probably 11 judges of the Supreme Court or even more. We have had situations where we needed more judges to make a decision. Apparently, if we are looking at those who are going to retire, we have less than the number, and the President in his wisdom have nominated qualified and competent professional bodies, lawyers, to be at the Supreme Court. I can only urge my colleagues on the other hand, on the other side of the act, that let us together resolve and approve this nomination. Thank you, Mr. Speaker.
Yes, one more. Yes, Honorable.
Thank you, Mr. Speaker. The Speaker rise to oppose the nomination of these two justices to the Supreme Court. The Speaker, the simple reason is that, as we recollect, I was on the Appointments Committee with you. And Mr. Speaker, I'm happy my colleague, Honorable Partisanship, was happily quoting Article 128 of the 1992 Constitution, 1284, that was talking about who qualifies to be a Supreme Court judge. But what he forgets to add to Article 296 of the 1992 Constitution, that mandates persons vested with discretionary powers what they need to do. The Speaker, with your permission, I will simply just quote Article 296 that of discretionary powers. I quote, where in this Constitution or in any other law discretionary power is vested in person or authority, A, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal, and shall be in accordance with due process of law. And C, where the person or authority is not a judge or other officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provision of this Constitution or that other law to govern the exercise of discretionary powers. Mr. Speaker, why did I choose to refer you to the discretionary powers? Mr. Speaker, with all humility, I've had the great privilege of vetting almost all the Supreme Court judges that are sitting on the bench today. And Mr. Speaker, you and I know there are three legs through which you can rise to be at the Supreme Court. One, either you are academia, where you have excelled in academia, and therefore you have been moved from the academia into the bench. The second leg is you have been in private practice, just like the Chief Justice. You've been in private practice and you distinguish yourself in private practice, that meets the minimum years. And the last leg, which is very, very important, you join the bench and rise through the bench to get to the Supreme Court. Mr. Speaker, there have been so few exceptions in the past where persons at the High Court have been appointed straight into the Supreme Court. Mr. Speaker, remember those times. How many judges do we even have in the whole country? You have at the back of your mind. What were the number of judges that were being trained? You have to have that at the back of your mind. And Mr. Speaker, the caliber of persons and the way they have practiced at the High Court before they were jumped into the Supreme Court. Speaker, one typical example is Justice J.N.K. Taylor, who was moved from the High Court into the Supreme Court. And Mr. Speaker, this is some of the pedigree of Justice Taylor, who was moved from the High Court to the Supreme Court. Justice Taylor served as a Crown Counsel. He served as a State Attorney. Served as a Director of Public Prosecution. He acted as Acting Chief Attorney General and Commissioner of Justice in 1960. As a High Court judge, he is the chair of the Taylor Asset Commission. Mr. Speaker, and he has served in these capacities, Mr. Speaker, with minimum of almost a decade and a half before he was moved to Supreme Court. Why are we seeing opposed to Justice Joe from a High Court to the Supreme Court? Mr. Speaker, check the records. Yes, he was in private practice. Supposed to join the bench. And the moment he joined the bench, in less than 2 years, you are jumping such a person from the High Court straight to the Supreme Court. When others have been on the High Court for more than 17 years. Mr. Speaker, now, the reason why I quoted 296 of the 1922 Constitution is that we are trying to check why was he being jumped in 2 years at the High Court to go to the Supreme Court. Only to notice, this is who has served as a parliamentary candidate for the New Patriotic Party on 2 occasions.
Hold on. Your point of order, please.
Thank you very much, Mr. Speaker. Right Honourable Speaker, I want to say that I was privileged to be among the 3 people who were nominated by the bar, the President Chief Justice, Justice Doche, and myself, because they are assessors and to go to the High Court for a period, and we were there. So it was done by the bar. Please,
Order, please. Order.
Yes, can I listen? Right, Honourable Speaker, those number of years he's talking about wasn't applicable. I chose that I was too outgoing to go to this. So I want to say that it is not the case that is strange. The bar assesses its own members and decides who they think have made a mark, and they would send you there, and you don't need to stay the number of years that I stayed there. Thank you, Mr. President.
So, what did he say that is not correct? Very well, please continue.
Thank you, Mr. Speaker. My colleague was simply waited to get an opportunity to espouse his views, because what he was going to say are flouted any of the rules or any of our standing orders. Now, Mr. Speaker, to continue. Mr. Speaker, this is a gentleman who has served as a parliamentary candidate for the New Patriotic Party on 2 occasions. And Mr. Speaker, very interesting, and this is worth mentioning. Mr. Speaker, I rightly said, with all humility, I have the great privilege of vetting all the justices that are currently sitting on the bench. Mr. Speaker, none of them who appeared before us at the time that he or she was a justice of the Superior Court, whether High Court or Appeal Court, was serving on any public board. This is the justice who is just about 2 years at the High Court and was still the member of the governing board of the whole hospital. Meaning that he was playing an executive function even as a judge. You cannot gloss over these anomalies. Because that's why I was saying to the Speaker, Article 296.
Sorry, hold on. On a point of order. Can I hear your order, please?
Mr. Speaker, I crave your indulgence that the honourable member Mr. Speaker, the honourable member was sick. The honourable member of Aswasi is misleading this House into some dangerous way. Yes, he has made 2 statements which will come back to haunt all of us here. He is saying, Mr. Speaker, somebody is being promoted to the Superior Court or Supreme Court of Ghana just because he has been twice any parliamentary candidate. Mr. Speaker, me and him was on the appointed committee of Parliament when we appointed for our General Secretary of PS. Mr. Speaker, that is not the first thing.
Honorable, wait. Are you on a point of order? So where's the order? Otherwise, this contribution, you can give it to your person. Send them out.
Mr. Speaker, we have a duty in this House to be true and candid. Mr. Speaker, what my honor is doing is really partisanship, introducing partisanship. It is not true and it's not being candid. When Akufo-Addo went to Supreme Court, he has been a General Secretary, he has been for one party.
Honorable Minister, please resume your seat. Please resume your seat. Honorable, there's just this point you made. I do not remember that it came out at the President's Committee, and I want to be clear that the nominee we are considering is a member of a governing board. I don't remember, it's in the report. Which page, please guide me. I am getting correction. Can you guide me? Which part of the
Mr. Speaker, it was part of the CV. And the CV, Mr. Speaker, because he presented it to the House, I want to believe that it's a public record. And we can help. And in the report, page 24 of your own report. Mr. Speaker, page 24, the last but one paragraph. The nominee also the nominee also informed the committee that he has served on all levels of the National New Patriotic Party (NPP), including position of presidency chairman, parliamentary candidate, His Lordship Justice Ernest Gawu again stated that he served the board of directors of the whole regional from 2020 to date. Mr. Speaker, this is your own report. And let me draw the attention of my colleagues. It is not a crime for anybody to have said a member of a New Patriotic Party or National Democratic Congress who was aspired to be at the Supreme Court. If that person has been at the High Court, has moved to Appeal Court, and is moving to the Supreme Court, he will have taken a trajectory that shows that when you join the bench, you go through the system, and you just simply don't jump at it. If that person was serving in private practice, what my colleague Honorable Andrew was speaking, he was serving in practice, private practice. Just like the Chief Justice today, he was in private practice. When you start in private practice, and they say the nominating authority saying it deemed fit to nominate you. Who will have issue with that? Because you are in private practice. But when you choose to join the bench, and then we are seeing a jump, we need to ask, what is instigating this jump? Mr. Speaker, I am deducing to say this is the reason why we are having this talk. Because one, he's shown in the own report that he is virtually in bed with this current government. And because of that, Mr. Speaker, he is given something that he doesn't merit, that he doesn't deserve. Because on the High Court that he joined about 2.5 years ago, he kept to meet so many other senior members. And today, he's not being just jumped to the appeal court, jumping to jump over the whole appeal court into the Supreme Court. At the time that, Mr. Speaker, we have so many at the appeal court that are marking time. That is the crux of the difficulty that we have with Justice Joe. And we are saying, Mr. Speaker, this House, like colleague Honorable Napo is saying, let Honorable Akufo-Addo is saying, let us be mindful of the things that come and haunt us. Because when you set a bad precedent, tomorrow it becomes a yardstick for others to make the same demand. And then we, the politicians who come to sit and make law, will become the victims. Because once we allow this to pass through, by the grace of God in 2025, when NDC is in power, others who are in similar situation will be using that as a yardstick to demand that they also be sent to the Supreme Court on the same, and what will we be turning our country into? Instead, President Nana is saying that of all the men and women at the appeal court, he cannot find a good replacement for the justices that are retiring, as Honorable Partisanship is saying, unless he picks a party apparatchiki at the High Court who will jump over all others and go to the Supreme Court. Mr. Speaker, let's be fair. And that is what the Constitution mandates President Nana to do. If he fails to do it, this House, let's adhere to Article 2 and make sure that we are holding these people accountable. We are not just going to sit and allow people to just off. When it comes to Justice Kumsin, Justice Kumsin has served on the High Court. Mr. Speaker, he also just go to the appeal court. I must admit, he himself, in answering the question, Mr. Speaker, with your indulgence, when he was answering this question about the number of justices, just alluded to the fact, and Mr. Speaker, this is on page 8 of your committee's report, where he himself acknowledges that, well, there must be some criteria by Parliament where we have a population that will show that if you are coming through academia, what should be the criteria? If you are coming from the bench, what should be the criteria? If you are coming from private practice, what should be the criteria? It will guide, because it is not fair. In this case, he thought that he has stayed at the High Court much longer. Now people are using his short stay at the appeal court and using that to judge. But how long has he served at the High Court? Nobody is talking about that. Because he also here is Mr. Speaker. He just joined the appeal court, also trying to meet so many senior other colleagues, and all of a sudden it's being hot. Mr. Speaker, if we approve this tournament, what we are doing to this country is simply turning our judges to become sycophants. Because through being sycophancy to the presidency or those in the corridors of power, you can just get hot from High Court, or you just join the appeal court within a short period, you just move on. And we will not be doing fair to ourselves and the citizenry. Because the Supreme Court, as you yourself saw, Mr. Speaker, per Article 128(4) of the National Constitution, requires individuals proving integrity. You cannot allow people that the Constitution itself says they must have proven integrity to become when they have to be running on the corridors of power so that they can be appointed. That is the reason why we on the NDC side believe that these two justices must not and should not be approved to go to the Supreme Court, we must send it back to the sender. The President must do what is right. He must adhere to Article 296, and when he is making the choice, he should have at the back of his mind that he must be fair, he must be candid, and his choice must not be capricious and must not be arbitrary. So, Mr. Speaker, without wasting my time, because, like we said, we have made our mind. These two justices, with all fairness and with all humility, we have no qualms about their individuals, their individual capacity. We hate them, but we are saying that we can sit and watch you just jump over others. And then tomorrow, when others want to come, they will use you as a, we don't want to set a bad precedent. And I'm calling on all of us, as members of this house, to know that yes, we will be willing to do the presidency bidding. But as we all are gradually turning ourselves into those powers outside, who tend to want to manipulate this house, we should be careful, because we will be weakening this house. And for once, yes, it's true, we have never rejected any Supreme Court justice here. But for once, let's tell the original, we are opening our eyes so widely, and let's set this good business to prevent a future government from using the same vehicle to bring people who simply are portraying or seem to be portraying to their whims and caprices is the reason why they are bringing them. If we do that, we'll be doing a great service to our country and our individual constituencies. I thank you very much, Mr. Speaker, for the opportunity to contribute.
Who will be the last contributor from here? Yes, Honorable.
I thank you, Mr. Speaker, for the opportunity to contribute to the discussion on motion to approve His Excellency's nominations for appointment to the Supreme Court. Mr. Speaker, Article 125 of our Constitution says that justice emanates from the people and shall be administered in the name of the Republic by the Judiciary, which shall be independent and subject only to this Constitution. Mr. Speaker, clearly the Judiciary is a very important arm that must be insulated from issues of partisanship and perception of bias. And as a member of the Appointments Committee, Speaker, having listened to all the nominees, I am very satisfied that the committee was right by its majority decision to approve all the nominees that are before us. I want to also respond to side, one of which is that even retired Honorable Dafia Mako, retired judges are asked to listen to cases. Mr. Speaker, I don't see why that is an issue, because if you read Article 145 of the 1992 Constitution, Article 145 clause 4, it clearly states that notwithstanding that he has attained the age at which he is replaced article to vacate his office, a person holding as a justice of a superior court or chairman of a regional tribunal may continue in office for a period not exceeding 6 months after attaining that age, as may be necessary to enable him to deliver judgment or do any action in relation to proceedings that were commenced before his previous to his attaining. So, Mr. Speaker, clearly the Constitution allows a retired judge to continue to listen for a period of 6 months. So that is even an issue to be raised here. Mr. Speaker, I have also listened to contribution from Honorable Muntaka, who today is expressing concern that people have been appointed because they have affiliation to certain political parties. Mr. Speaker, I am very, very disappointed at that argument, because this is not the first time in our country that Indians who have been appointed to the highest part of our land have political backgrounds. Mr. Speaker, let me make references. to such individuals. One of them is Justice Kobia and Justice Appel, who currently are the Supreme Court. Mr. Speaker, the chiefs of the then PNDC government, and they were appointed under the NDC government. Mr. Speaker, nobody raised concerns when these individuals were appointed. Secondly, Justice Boom and Wadi, in fact, Justice Wadi is a two-term NDC MP. Justice Wadi is a two-term NDC MP. Mr. Speaker, as we speak today, the whole High Court serving, and he's working excellently. So, Mr. Speaker, in fact, he even presided over the election petition that involved Honorable Peter John Amewu, and we didn't raise any concern. The NDC was happy to send election petition to a former MP who was currently a judge. And today, you stand in this house to complain that somebody has an MPP affiliation and should not be appointed. How double standard can you display in this house? So, Mr. Speaker, let us not give merit to these statements from the NDC. Let us focus on the competence of the individuals that have been nominated by His Excellency the President and give them the opportunity. Mr. Speaker, how are these individuals selected? And I will forgive Muntaka because he's not a lawyer. He has not been in the practice. So his assessment of how people must be nominated, I will forgive him. But Mr. Speaker, anybody who has been trained as a lawyer in this country understands how judges are appointed. In fact, Mr. Speaker, one personal experience is that I, as a young lawyer, was in a matter with Justice Appel when he was a practicing lawyer. On the same day when his name was mentioned to go to the Supreme Court, he was a practicing lawyer. Mr. Speaker, he had not even had 1 day of a judge experience. How do you question somebody? And that was done, that appointment done by President John Mahama and the NDC. How do you question President Akufo-Addo's appointment of an individual who has served 2 years as a judge at the High Court? You can appoint somebody who is a practicing lawyer.
Yes, honorable example.
Mr. Speaker, thank you very much for the opportunity.
Members, can I have some order, please? I want to listen to him. Yes.
Mr. Speaker, I heard my honorable colleague say that there's a future NDC MP.
You didn't say it.
I refer honorable to future NDC MP.
Honorable example.
We have members of Parliament.
If you heard future, you heard wrongly. He mentioned names. He said a two-time MP. Yes. When he is a sitting High Court judge in That is a fact.
And he proceeded by concluding that a future NDC MP.
He didn't say that.
We don't have future NDC MP.
He didn't
We
say
have
that.
sitting members of Parliament.
Madam, please continue.
Mr. Speaker, clearly, my friend didn't sleep well last night, and that is why he two-term as future. Mr. Speaker, Mr. Speaker, thank you, Mr. Speaker. Mr. Speaker, another allegation that has been made by on the other side, Honorable Suhini, said that after the committee hearing, some of the members complained about the competence of one of the nominees. Mr. Speaker, I want that record to be expunged because there was no such discussions of unsatisfactory performance or incompetence by any of the nominees. Mr. Speaker, that is not even contained in this report, and I don't know where he's getting that information from. And I plead that we expunge that information from the Hansa. Mr. Speaker, clearly the competence of the nominated judges are clearly this. And if you read paragraph 4A, the perceived lack of transparency in the progression of judicial officers. Mr. Speaker, the nominee even took time playing to the committee that the system, the judicial service, has a way that they assess every judge and every magistrate in our country. He explained that at the end of every legal year, judges are required to submit judgments and rulings to the evaluation department of the judicial service, but he's not privy to what and how these considerations are done. So, Mr. Speaker, there is a format, a system, a process by which individual judges and magistrates of our country assessed by the judicial system. So it makes them accountable. It is therefore unthinkable anybody in this House to say that there is no basis for His Excellency to nominate the people that he has put before us. So, Mr. Speaker, clearly the concerns about competence is out of place. These individuals have shown that they merit the opportunity to serve at the highest level, and it will not be the first time or the last time anybody with a background will be nominated to the highest court of the land. Mr. Speaker, the previous people who have been nominated to the court, the Supreme Court of Ghana, have proved that their political backgrounds really do not matter when it comes dealing with legal issues. Legal issues are assessed on basis of the law and basis of the facts. So, Mr. Speaker, let us, and the evidence before the court, let us disregard all these baseless sentiments and approve these individuals that have been nominated by His Excellency the President to go to the Supreme Court. I thank you, Mr. Speaker.
Now, leaders. Do the leaders wish to contribute to this debate? No. Very well. Enough members. That brings us. Very well. The minority. And 3 each. Okay, we have done 3 each. No, we didn't hear you. Since you were going to allow leaders. Okay. I've done 3 each. You are now doing it. Okay. We agreed 3 contributors each, and we have done 3 each, haven't we? I think that's enough. That brings us to the end of the debate of the report. Now, our rules are clear. Where we are not ad idem, the recommendation is not by consensus. We make the decision by a secret ballot. In this case, I think we will now defer to the Plaza table to organize and prepare members. Here is the Honorable Majority Leader.
Mr. Speaker, I wasn't at the President meeting, but the information that I had was that the Speaker had indicated that he wants to be in the chair to preside the voting. If that is true, the Speaker, then we can put that aside, awaiting the Speaker, and deal with the revenue bills. And deal with the revenue bills, debate them, and then when we are through, the Speaker comes, we take all of it. Speak, amen.
Yes.
Mr. Speaker, I agree with the leader because we are about to pave the way for the voting. But yesterday, we decided that the Common Fund will come here with their formula. Mr. Speaker, as I can see, the Common Fund administrator is sitting right there. So instead of starting a new business, I can hear you know. You want the vote, isn't it? We should break into committee of the whole and consider the Common Fund. Or Mr. Speaker, apart from that, then Mr. Speaker, can you restrain my colleagues?
Honourable members, order, please.
Thank you, Mr. Speaker, for the opportunity. Either we allow the Common Fund administrator to bring back, or we wait, or you suspend. Because I know, or we suspend. We suspend and wait for Mr. Speaker and come for us to take the vote, Mr. Speaker. Because this is a major, Mr. Speaker, the revenue bills are a major undertaking, and we are thinking that we need enough time to do that. So instead of starting and stopping, we should that we should suspend and allow Mr. Speaker to come to the chair. So we take the vote, Mr. Speaker.
Yes. Speaker, I listened to my colleague, but it's important we communicate the facts. It's important we put the facts across. Speaker, with respect to my colleague, Minority Children, today a conflict, and Speaker, you bear me out. Among the items that were considered to be taken on the floor, we never mentioned the common fund. These were the items we talked about. We talked about the motion on the Supreme Court Justice. We also talked about taking the question on the ministerial and deputy ministerial nominees. And then, of course, the financial revenue bills. The common fund matter was an agreement between you and I. Of course, the meeting we had and leadership supersedes the meeting the two of us have. So please, this is not a matter we have to split our heads over. We shouldn't split our heads over this. The Speaker has given indication. We are ready to take the vote. If the Speaker, in the absence of the Speaker, we can go on.
The Speaker is here.
Exactly. Then we go ahead and take the vote. We go ahead and take the vote. Are we ready for the vote? We are ready for the vote.
Honourable members, I've heard both sides now. Can I have some order, please? Can I have some order?
No, Mr. Speaker,
As the floor, Honourable, as agreed at a conclave, after the debate, we will take the vote. Mr. Speaker has just sent his class to advise me that he's here. So the table office will start preparing while the Speaker comes to take the charge. The Speaker will be here in a moment to take the chair, and then we'll proceed with the vote. Thank you. Speaker.
Yes, Honorable Leader.
Mr. Speaker, with respect, I think we have signaled that is within the presence. He wants to come and persuade us to take the vote. We have not suspended sitting. And in the meantime, if we can take the revenue bill before he comes, because we cannot wait here doing nothing when the House has not been suspended. We can't continue to wait here. The House has not been suspended. There's business for us to transact. And so here, we'll have to sit down. I'll agree with you. Let's start revenue bill. We are not going to take any vote. I'm not going to take a decision on them. I will do the consideration of bills. When he comes, we'll be part of it. If we have to vote on them, we'll be part of it. Otherwise, would anybody then agree that this is deliberate? Today is Friday. And if you have to wait, the Speaker, let me then sound that the three businesses certainly we are going to transact. Whatever happens, the three businesses we are going to transact, even if you have to sit up to 12 midnight. With the greater respect.
Thank you, Mr. Speaker. Mr. Speaker, if you recall yesterday, what the agreement was that after the debate this morning, we will come and vote on the ministerial appointments. When we went to conclave, the issue of the judges was brought. And we agreed that we come in and then we do the debate, and after the debate, we will now vote on the ministerial appointment and vote on the judges. That was the agreement. So we should go ahead and vote. And then after that, we will now look at what time we have and see what other business we can do. That's what we agreed on. You talked about the other economic bills. And we said after we have taken all of this, let's vote. So we are at the point where we should be voting. And as you suggest, the speaker is coming to take over. And we said that you can take a suspension while we wait for the speaker. So if that is the case, we suspension. Because where we are right now is to vote. So Mr. Speaker, that is where, and nothing else.
Honorable colleagues, we are here because of the table of to set up the voting system. Mr. Speaker will come when the place is ready, he will take it over. But the table of to set the place up. We then take the chair.
Honourable members, please lend me your ears. I've just been given a detailed brief to what transpired this morning. And yesterday at the meeting of the Joint Caucus, honourable members, hope you are listening to what I'm saying. Because I want you to guide me as to the procedure we should adopt. We have a guide from our standards, but definitely in some of these situations, to get things smoothly done, we need the members to be involved in the final decision. Yesterday, for good reason, we deferred taking a decision on the motion to adopt the report of the Appointments Committee in giving a prior approval to the appointment of ministers and deputy ministers. We deferred it to today. This morning, we've gone through that one, the motion dealing with the nominations of members to the Supreme Court. I've been briefed that at the Joint Caucus meeting, you agreed to have both taken at the same, that is the vote on the judges and the ministers. I want to know whether that is the case, so that we know the system to adopt.
Thank you, Mr. Speaker. Mr. Speaker, as I conclude this morning, we have said that these are separate motions. The decision on the appointment of the minister and the judges are separate motions, and we agreed that we will vote on them separately. And that was the agreement.
Yes.
So, Mr. Speaker, we agreed to vote them separately at the same time. So we are going to have one ballot box, just as on the national elections we vote presidential and parliamentary. You are given a ballot for presidential, you vote to put it in a box. You are given a ballot on parliamentary, you vote to put it in a box. The position is that we are going to have two ballot boxes, have separate voting but at the same time. So you go, the clerk gives you one ballot paper which has the list of the ministerial nominees. You finish voting, you pick another one for the Supreme Court judges, and then you put it in. Mr. Speaker, that was the understanding, and Mrs. The first deputy speaker who presided is here to validate the points I've just made. Thank you, sir.
Yes.
Mr. Speaker, it is true. Mr. Speaker, it is true that the respected deputy leader made the suggestion at conclave that we should do what he is describing. We said no because of the controversies. Mr. Speaker, there are two different motions. We are already here to take the vote. We should go through the first motion, take the vote on the ministers or the judges, count
declare it, then we go on the second one. That there was no agreement. Do what he said. He did make the proposal, but there was no decision on that. That is the fact, Mr. Speaker.
Members, let's listen to the person who presided over the proceedings of the joint caucus meeting, the first deputy speaker. Yes.
Thank you, Mr. Speaker. Mr. Speaker, it is true. I propose that we do the two votings together, two separate boxes. From one end, we continue to the other end. There was no agreement between the two sides. So I told them that actually decision is to be made by Mr. Speaker. So if we can agree, we should leave that and come here. So we'll leave you to make the discretion. That was how we concluded.
Well, honorable members, in this matter, I am the Electoral Commission. After listening to the chair, I cannot listen to you again. Please. I agree with those who are proposing that there are different motions and we should take them differently. And so we'll take yesterday's one first. The one dealing with the nominations of the ministers and deputy ministers. Then I'll declare the results. Then after that, we'll deal with it today. We have enough time to do that. I'll be here throughout. These honorable members is secret vote. I want to emphasize on the word secret vote. If there's any slight evidence that the vote is not secret, it will not be accepted. Without that, as you know, I survived through secret voting, so I treasure secret voting. I am the Electoral Commissioner. Yes, so let's start with the vote on the now nominations. What we're going to do is that we're using the list of names of the members of Parliament. And so you all be seated. And when your name is mentioned, you move forward to be given the ballot. You go and vote and then move back to your seat. Your seat. We are not going to talk about people standing. You have to be seated. Your name will be mentioned, and that is why we need you to be quiet. If not, you will not hear your name to come to vote. We have the ballot papers, they are ready. Yes. Honorable Mama Yarga.
Thank you very much, Mr. Speaker. Mr. Speaker, you have explained some aspects of the voting procedure. In the case of both the ministers and we have a number of nominees. You haven't going to ask how the ballot paper is going to be presented. So the nominees and then the provision for voting. When it was you alone, Mr. Speaker, it was clear. It was just you, and then provision was for voting for or against. But since there are several nominees, how is the format of the ballot paper going to look like? We just need some clarification.
This is a sample ballot paper. Ministers and deputy ministers, one ballot paper. The boxes yes and no are indicated against the names and the proposed sectors they are to preside over. So you indicate in the box whether yes or no. So there is one. We have a way counting, and then we will then ask you to nominate tellers to be available for the counting. So please, this is for the ministers. The judges, we have, there are two categories, two names. The first two names, I'm told, there's not much controversy concerning that. Then the other two, where you have some differences, they are also together. The ballot paper is there. I can show you a sample. The other ballot paper, or the changes. Good. Honorable members, sample ballot for the judges. Yes, Honorable Mama Yarga.
Mr. Speaker,
Yes.
we just wanted to also know whether you brought a CI to this house to govern the design of the ballot paper.
CI on what?
A CI on the design of this ballot paper. The design of the ballot paper.
Honourable member, are you a 5'10", 5'10" member of Parliament? This is from practice procedure. Please, there are too many of you on your feet. We don't need any disruptions. We don't need obstruction. We don't want to hear. You have to listen to us. Honourable members, we are now to commence the process. When your name is mentioned, please walk up to the table office. You'll be given a ballot. You proceed through do your voting and get back to the table office where the ballot boxes. We don't want many of you piled at the table office. Please. Yes, Deputy Minority Whip.
Thank you, Right Honourable Speaker. Mr. Speaker, we are requesting for copies of the voters register to be given to our two polling agents. One, I will sit here and be marking, and the Honourable Minority Chief Whip will stand at that place and also be marking. So as agents, we need copies of the register, and we must set a good example. This is a harmful request.
Honourable member, you are completely out of order. I've indicated that we are going to use the list of the members of Parliament. That is the register. And we have indicated that we will call you by your name and your constituency, and you walk out here to the glare of every person gathered here, including the gallery. And so if you are an imposter, we will identify you. I insist that this is secret. Secret means secret. Please, I'll be very, very vigilant myself as the Electoral Commissioner. And I have the power to disqualify a voter. Yes, so let's start. We will go by alphabetical order. Yes. Deputy Majority Leader. Honourable members, be seated. The time for Camboba. Yes, Deputy Majority Leader.
Mr. Speaker, thank you for the opportunity. Mr. Speaker, I'm on my feet to
seek your guidance on Article 78 of the Constitution, as well as Order 172(4). Mr. Speaker, Article 78 provides, and with your leave, I read, that ministers of shall be appointed by the President with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament, except that the majority of ministers shall be appointed from among members of Parliament. Mr. Speaker, for my purpose, the emphasis is the prior approval. And the Constitution under Article 78 does not state the procedure for giving this prior approval. However, Mr. Speaker, if you go to Article 110 of the Constitution, the same Constitution says that Parliament, subject to the provisions of the Constitution by standing orders, regulatory procedure. Mr. Speaker, we have had several occasions in this House where we have used practice to set aside the standing orders and in on the Constitution. Mr. Speaker, there are some other provisions in the Constitution that talk about secret ballot when it comes to electing or removing a person from public office. Mr. Speaker, what we are doing is not an election. We are approving. And I know that Order 172(4) provides that the committee shall report to Parliament within 3 days after it has concluded its proceedings when Parliament is sitting. Parliamentary approval of personnel for appointment shall be by secret ballot or by consensus. So, Mr. Speaker, although the Constitution talks about prior approval in general terms and does not provide a specific procedure for achieving that, our own standing order creates two main avenues of disjunctive effect. Mr. Speaker, I am bringing argument forward because yesterday, and I'm quoting my respected colleague, Honorable Akufo-Addo, and my respected colleague, Honorable Anobomfre, when there arose an occasion to have further engagement on this matter, I recall that Honorable Akufo-Addo said that we are all members of Parliament and that our colleagues in this House, that we should not take ourselves through that burden of having to engage in a secret ballot. Mr. Speaker, that move occasioned some discussions, and Honorable Anobomfre, in applying for stay, relied on that to say that, Mr. Speaker, we want a 1-hour suspension so that we could explore the possibility of dealing with that issue. Mr. Speaker, the argument here is very simple. Our colleagues in the minority, who are 136, have made it clear that they are opposed to these nominees. So, Mr. Speaker, I am saying that we are masters of our own roots. Mr. Speaker, if we decide, perhaps, to be masters of our own rules without sinning against the Constitution, we will be acting within the lines of the Constitution. This is a subsidiary legislation that we have enacted, that day in, day out, for our purpose, we take a decision and say that this is a malpractice, and we go by it. All I am saying that, Mr. Speaker, to the extent that the 172(4) gives a disjointed effect in its import of what is required in taking such a decision. And one is by consensus. If we achieve consensus, and we know as a fact that the whole 136 of the minority are against, and the whole 137 of the majority are for, Mr. Speaker, I invite this out to construe and appreciate within the context of that to mean that, Mr. Speaker, we can adopt of that consensus, Mr. Speaker, which would mean that the decision for the approval, because we are not elected, so, Mr. Speaker, the argument I'm making is that the provision for secret ballot in itself is not provided for by the Constitution. And let us know, any student of Constitution knows that we cannot by an enactment create a law that would overshadow, or be at variance with the Constitution. Mr. Speaker, I repeat that we as a House have the mandate under Article 110 to enact our own regulations. But, Mr. Speaker, we cannot, in enacting our own regulations, seek to enact a law that would be at variance with the Constitution. Because, Mr. Speaker, anywhere that the Constitution wanted a secret ballot, like in your case, can I finish this constitutional argument so that you tell me, Mr. Speaker, I'm protected by you. Mr. Speaker, it is my submission that anywhere the Constitution has intended a secret ballot, Mr. Speaker, it is essential that anywhere the Constitution had intended a secret ballot, the Constitution has said so. Two, where the Constitution vetted of us to enact a regulation to guide our conduct, the Constitution has also provided for. It is therefore my case again, Mr. Speaker, that to the extent that the Constitution gave a general approach to guide us, we as a House cannot, through our enactment, restrict and provide for a very thinner approach in achieving that purpose of approval. We are not elected. And anywhere the Constitution has talked about electing a public officer, it emphasized secret ballot. And that was the case. So, Mr. Speaker, I shall land.
Honorable Party Leader.
Yes, Mr. Speaker.
You have landed. And you have landed very well. Yes, you have landed very well. I'm sure you know one very popular former member of Parliament, filibuster. You know filibuster.
Mr. Speaker.
Do you know filibuster?
Mr. Speaker, I know that you have not prejudiced my submission. Mr. Speaker, I know that you enjoy debate and you always want us to learn. Therefore, Mr. Speaker, if you are putting the question to me whether or not I know,
he was Speaker,
on my
admission. That's what in any way I'm not.
He was a well-known member of Parliament, and by his practice, the word filibuster was formed. The filibuster of this House. So I have elevated to a very high position because that was an initiative and a practice that has been adopted all over the world. And I've seen that in you. And so that is just done. Definitely, as Speaker, I'll just overrule you and we'll proceed. Honest, we are just creating space to finish up with all the nitty-gritty of the process. That's why I'm allowing this. We have given you now copies of the list of members so that you can go through as we call you up. Have you got the copies?
Yes, Mr. Speaker, we have 2 copies as you directed.
Okay. Majority side, you got the copies, the list. Yes.
Mr. Speaker, I encourage my colleague to speak to the mic that yes, he's got 2 copies as well. It's important, Mr. Speaker. Have you got 2 copies of the members' list?
Mr. Speaker, he should not invite me into unnecessary battle. He should not. Who has complained? Who is complaining?
Marshal Department, please get ready to perform their duties. Read your standard orders. You get to know the role of the Marshal.
Yes. I think the arrangement that I'm seeing here, the person will decide how to vote in one of them and drop the box here. Okay. So just one ballot. One box. That's right.
We will not encourage crisscrossing. So, honorable members on my left, the ballot box is here. Clerk at table, please, let's start. Abata somewhere. Repeat. Abata Samuel Erickson.
Honorable members, please be on your seats. Members, please be at your seats. Honorable members, either you want to vote or you don't want to vote. If you want us to conduct the vote to indicate our prior approval, resume your seats. Please. If not, I will suspend sitting. It's in the standing orders. I am not going to recognize any person to make contribution. Please, resume it. You are all campaigning and you are expecting your constituents to vote for you. Yet, you are...
Honorable members, if you were listening to me, I invited the personnel of the Marshal's Department to get ready. So we have some personnel from the Marshal Department on my left and we have some on my right. The purpose is for them to perform their duty when called upon by the Speaker. The standing orders are very clear. If you doubt it, read your standing orders. And so we are going to start.
Mr. Speaker, sitting here, you can see that the box on the left is tilted towards you. The same thing, the box on the right should be tilted towards you. So we avoid any intrusion from the right. But the Marshal keeps turning it to the other side. That's what I'm complaining. If you turn it towards you, that's right.
I think the ballot box on this side has been tilted to your side. In fact, we are worried that you will even see the ballot. I'm suggesting that you allow the first deputy speaker to come up and show us exactly where he wants the people.
Honorable members, let me assure you that where I sit, I can't see anybody indicating where the person is voting. I can't. Both ballot boxes, I can't see. The ballots, I can't. So you are safe. But the doubt is deep. The lack of trust in each other is really deep. So please, the right thing will be done.
Yes, Majority Chief Whip.
Speaker, with respect, I think this is a point that we shouldn't belabor. Members are trying to help the process to be sanitized, free and fair. Speaker, one of the approaches that will help us to avoid things not being transparent is that we on your right side will vote on your left side. And then out of the left, you vote on the right. This will avoid anybody showing it to the other side. That is it. I insist. We are suppressed. It's a threat. We keep strong. Nobody will show a ballot paper to another. And this position will avoid any voter showing the ballot paper to the other side. You want to show your vote? We will allow you. In secret, you will show. Yeah. So that's my humble plea. And no respect, this will save us all this hassle. Let's just push forward, and all of us will save this hassle. Please. Minority Leader. Mr. Speaker, clearly our brothers on the majority side are afraid to vote today. Mr. Speaker, the antics they are showing clearly shows that they are not ready to vote today, and they are afraid. They are afraid. Mr. Speaker, the suggestion by the majority chief whip indicates that they want to come and sit this side of the house. Mr. Speaker, if they hurry to come to your left, that is the opposition, we welcome them to come and sit here, so that we go and sit there. Mr. Speaker, we will not agree. We will not agree that members on this side should this way. The Speaker, concentrate at your back and rather get your back to vote for you. The Speaker, we strongly disagree. The Speaker, our position is that cannot happen. We disagree. And if they are not ready to vote, the Speaker, today is Friday. Our colleagues, the Muslim community, we are in a Ramadan period. The Speaker, then let us suspend sitting and come back next week to continue. If they are not ready, but we are ready. But if they are not ready, let's go. They are afraid to vote. They are afraid to vote. We need to vote. Go and sit down and let's try to vote. Then we can read the vote. Thank you, Mr. Speaker. Assure my colleagues, about when we came in the morning, if you recall,
Honorable Majority Chief Whip, I haven't recognized you. You can't just get up and ask me. Honorable members,
I've made my point. In this house, the practice has been.
Honorable Majority Chief Whip,
Should resume my seat?
you resume your seat. Honorable members, I invite the leadership of the House to meet me in my lobby. Taking is suspended. So today is Friday. You are losing. Who are you?
You're still watching City TV, and just gone by was what was transpiring in the House of the Legislature. Early on, we saw a debate by the members of Parliament on the back of the ministerial nominees by President Akufo-Addo, and also the expected voting that was to take place not too long, but the Speaker has suspended sittings. We'll be bringing you more with regard to that, and for that matter, we'll go over the phone lines and talk to my colleague, Ni Ayikwe. He's standing by with more. Ni Ayikwe, many thanks for your time. So we've seen that the Speaker has suspended sittings, some sort of issues with regard to the voting processes for both factions, that is the majority and the minority. But before that, tell us what transpired over the period before we got to the suspension of sittings.
So this morning when the House was being what we were all expecting was to see a vote being taken on the Ministers of State appointed by President Akufo-Addo, as it was directed by the Speaker of Parliament, yesterday. But that was not done. We rather had the House debating on a report of the Appointments Committee of the Justice, two justices that were appointed in the Supreme Court by President Akufo-Addo last year. And if you will recall, the Speaker of Parliament was not around. So it says that the ANC was the one chairing the debate, and they revealed that they could not take the vote on the justices of the Supreme Court, but rather wait to the Speaker of Parliament and them by the in the House before they would be able to take the vote on the justices of the Supreme Court, the debate on the justices of the Supreme Court. We waited for Adam Baldwin to be in to preside. And when it is over, he indicated that they are going to cast the vote on the Ministers of State appointed by President Akufo-Addo, as well as the two justices of the Supreme Court. Previously, the majority proposed that, if possible, the two votes should be taken concurrently, while as the vote for the ministers are taking place, then that of the ministers are taking place, that of the justices will also be conducted concurrently. But the Speaker ruled that they will be done on different days. So the Speaker repeated that they are going to vote on the ministers first, after which the results will be announced, and then they move to the second motion, which is the Supreme Court justices, for them also to be voted on. But right upon the voting expected to begin, some of the majority members were not really in support of this. I think the majority staff we are saying that they are very much aware that they have 147 of the members and the minority has 20. So if that is the case, then they should have a voice vote or a consensual vote just to approve the nominee. But the Speaker will this is a motion that requires that every member of the House participate in the vote. There's a need for the Supreme vote structure. At the time, we've had disagreements there and then between the majority, and the minority has even how the ballot box institution. So they were calling for the ballot box institution appropriately. That was done. And the majority also proposed that they will take the side of the minority, while the country also comes to vote or cast their vote at where the majority is attacked. That was also not active. So it's been disagreement on how to conduct the city's vote. So currently, the Speaker of Parliament, Adam Baldwin, has suspended to engage leadership of both sides of the House over the matter.
From where you sit, are you able to paint a picture of the numbers in the House? Do we know which members of Parliament are absent, for which reason it has become, a concern for both factions?
Come again, please.
Well, so I'm asking that from where you sit, are you able to give us the number of members of parliament who are absent from the House, for which reason it has become a major concern with regard to the voting that was expected to take place some few minutes ago?
So what we know is that the minority members are 136 number. Now, if I'm not telling lies, I would say that all of them are available. Because it's only been articulated that they is one, so they still have 136. And then at the majority side, we don't have a black couple who is a member of parliament for the around. So they are 137 with the independent candidate. That's if you have the independent candidate who also doubles as the second of this speaker, Andrew Amo, so they will be 137. But for the minority, they are 137. At the moment. But we don't know what exactly is causing the delay in the voting day. For which reason there are disagreements here and there on both sides of the House.
Nia Akufo-Addo, I'm grateful for your time this afternoon. Hopefully you monitor proceedings and join us later in our bulletins for 2020 and on the City Newsroom. Nia Akufo-Addo is a parliamentary correspondent bringing us up to speed with regard to the expected voting to take place in Parliament with regard to the ministerial appointments and also the appointments for the Supreme Court justices. And we'll be bringing you more subsequently. I am Kwaku Aduamansa. Many thanks for watching.